The question of board liability naturally arises.
Both executive boards and supervisory boards are considered corporate officers. Therefore, in the event of a criminal offense, they may be held legally liable. The board is not responsible for financial results. It does not interfere in day-to-day operations.
Negligence is a type of allegation that, in practice, can be brought against almost any executive on virtually any issue.
Business decisions are, by their nature, risk-based.
This is not a casino. Decisions must be grounded in careful analysis and sound judgment. Ladies and gentlemen, welcome to the Board of Directors with Sergiy Bulavin channel. Today our guest is Sergiy Shkliar. Sergiy, good afternoon.
Good afternoon.
Sergiy is a co-founder of the law firm Azinga. He also serves as a member of supervisory and advisory boards of Ukrainian companies, including as a member of the Supervisory Board of the municipal enterprise Mykolaiv Vodokanal. In light of recent developments involving state-owned enterprises and their supervisory boards, the issue of board members' liability has become particularly relevant. Participants in the course I teach at CGPA and at Kiev Mohyla Business School frequently raise questions about the liability of supervisory board members, and this concern extends beyond state-owned or municipal enterprises. It is equally relevant for private businesses. That is why Sergiy and I will now discuss the issue of board members' liability. Sergiy, I assume that the liability of board members largely depends on the type of board, whether it is a supervisory board or an advisory board. How exactly does liability differ depending on this structure?
Yes, indeed. It is a set of responsibilities for a supervisory board, a board of directors, and an advisory board, including hybrid formats. In addition, there are specific considerations for state-owned enterprises, as well as particular regulatory nuances for financial institutions, including banks, insurance companies, and others. In other words, certain factors may expand the scope of liability. Liability as such may take different legal forms. Depending on the type of board, there are at least 4 categories of liability: civil, criminal, administrative, and regulatory. The latter being particularly relevant in the banking sector. Civil liability primarily involves compensation for damages. This includes so-called derivative actions filed by participants or shareholders on behalf of the company and in its interests. Such claims may be brought against members of supervisory boards or against executives, and whether executive or non-executive director, with the aim of recovering losses. This practice is already emerging in Ukraine. In addition, there may be criminal liability. First and foremost, members of supervisory boards as corporate officials are subject to criminal liability under the relevant provisions of the criminal code applicable to officials. For example, a corporate secretary is also considered a corporate official. This position is mandatory in state-owned enterprises as well as in banks and other financial institutions. However, regardless of where it exists, it qualifies as an official role. Other individuals may also qualify as corporate officers, for instance, a head of finance, as well as those designated as such in the company's charter. Therefore, this must be assessed on a case-by-case basis. It is important to understand that both executive boards and supervisory boards consist of corporate officials. Accordingly, in the event of a criminal offense, they may be held liable. Administrative liability is also possible, though it generally concerns minor violations, most commonly related to failure to submit reports or delayed reporting.
If we compare liability in supervisory boards of state-owned companies, municipal enterprises, and private businesses, the scope of liability should, in principle, be largely similar. The key difference lies in the owner, who may choose either to enforce such liability or not.
Well, yes, of course. In addition, private businesses are not always required to establish a board at all. This remains their prerogative, and we are still in the process of developing this governance culture. Those of us who work in corporate governance, including you, constantly advocate for why boards matter, what their role is, how they differ from executive management, and how they differ from shareholders. Because even owners of well-established Ukrainian companies do not always fully understand this distinction. Moreover, in Ukraine, most business owners are first-generation founders. Their companies are their children, something they built from scratch, and it is understandably difficult for them to step back from operational control. That said, there are institutions, including private ones, where a board is mandatory, for example, banks. In state-owned enterprises, supervisory boards are required by law. In municipal enterprises, however, this is not yet formally mandated. What we are seeing now is more of an emerging practice. This is only the second water utility with a supervisory board, the first being in Lviv. In such cases, the establishment appointment of a board is largely at the discretion of the owner and remains voluntary. In addition, beyond accountability to the owner, members of state-owned and municipal enterprises bear certain public law obligations. For example, they are reporting entities before the National Agency on Corruption Prevention, NAPC, and are required to submit asset declarations. There are differing views on this requirement. Some argue that board members should not be required to file declarations. Others believe they should. In our supervisory board, we concluded that we are obliged to file, and we did. Although there is a draft law, I am not sure whether it has already been registered in Parliament that proposes abolishing this requirement as it discourages qualified candidates from participating in selection processes. In reality, there is nothing particularly alarming about filing declarations. I previously served for 3 years as a deputy minister and submitted them at that time as well. It is not problematic in substance, but it does require time and administrative effort. Moreover, even an unintentional mistake in a declaration may lead to unpleasant consequences. That factor can also be discouraging.
The obligation is effectively lifetime. It is not time limited.
Initially, it was not intended to be lifelong, but at some point legislators decided to make it ongoing. To the best of my knowledge, in other countries the requirement is usually limited, for example, to 1 or 3 years after leaving office, after which the obligation ceases. In other words, you may still formally qualify as a PEP, but you are no longer required to file asset declarations.
Many private business owners are genuinely concerned about their companies and about the people they invite to serve on supervisory boards. Their questions about liability are entirely legitimate. From the owner's perspective, the thinking is often as follows. Let's step back from day-to-day operations. These individuals on the supervisory board will now stand between us and the company's management. They will effectively perform some of the functions that we previously carried out ourselves. We, as the owners, how will these board members be held accountable for potential problems in the business? I, as the owner, have always borne responsibility with my own assets, my time, and the capital invested in the company. So what liability will be applied to members of the board of my company?
If it is proven that, as a result of the board's actions, the company was driven into bankruptcy, for example, through the sale of assets at undervalue, transfers to affiliated parties, issuance of unsecured or improperly secured loans, then, first of all, the criminal code provides for liability for bringing a company to bankruptcy. In such cases, supervisory board members may indeed face liability. This liability may be joint and several, potentially extending to owners and shareholders as well, and may also be subsidiary if one party's assets insufficient to satisfy claims. Much depends on the legal form of the company, whether it is a limited liability company, LLC, or a joint stock company. As a general rule, if there has been no wrongful conduct and no deliberate bankruptcy, then liability is limited to the shares or ownership interests held in the company.
A particularly important issue for business owners, for the boards they establish, and likely for state-owned enterprises as well, concerns liability not for bankruptcy, but for deterioration of performance indicators. Such deterioration may occur for external reasons beyond the company's control, including market downturns, market conditions, force majeure events, and so on. However, in theory, declining performance could also be linked to certain actions or inaction by top management or even by members of the board.
We know this, you and I, for the viewers. The board is not responsible for financial results. That is not its mandate, and it does not interfere in day-to-day operations. It may, however, contribute to improving results indirectly, for example, by setting KPIs. It can also support performance through attracting investors or strengthening oversight mechanisms. But fundamentally, it does not generate financial results itself. The board is responsible for strategy, internal controls, and corporate policies, and so on. Indirectly, of course, it may influence outcomes, for instance, by reducing corruption risks, implementing sound governance policies, and ensuring proper supervision. However, it is not accountable for the financial result as such. That is not its function. Moreover, there are enterprises that are inherently loss-making, including municipal companies, and in many countries around the world, such utilities operate at a loss by design. There are, of course, exceptions. I know you will be speaking with the chair of our board. She can share some interesting examples. Singapore, Las Vegas. I will not go into detail here. In those cases, water utilities are profitable, or at least break even, largely because they operate at significant scale. They supply large volumes, often beyond their domestic markets, and may engage in additional commercial activities. For example, some produce and sell byproducts such as fertilizers, but that is a different story altogether.
In the courses I teach, participants occasionally raise a challenging question. What happens when there is no objectively right decision? There are situations in which any decision the board makes can later be interpreted as wrong and may have consequences, including for the company's economic or financial position. We operate in an environment of limited resources. For instance, funding must be allocated among multiple competing priorities: equipment modernization, employee retention, and other essential needs. In reality, it is rare to have sufficient resources for everything. A compromise is almost always required, and compromise inevitably carries risk, as certain choices may later contribute to difficulties for the company. For example, management, together with the Supervisory Board, may decide to prioritize modernization, but due to limited resources, part of the available funding may ultimately be redirected toward maintaining the workforce. In effect, the program was not fully funded. Subsequently, something happened to the equipment. For example, the lead time for replacing the equipment is 6 months. As a result, the production line, or even the entire enterprise, is forced to shut down for half a year while waiting for the necessary spare part. Does this give rise to liability for top management and for the entire board that approves such a decision?
Each case must be assessed individually, but let us begin with a fundamental point. Any practical decision taken in business involves risk. Companies survive and grow not because they never make mistakes. Such companies simply do not exist. No organization operates without error. Success belongs to those that make the right decisions 80 to 90% of the time, even if 10 to 20% turn out to be wrong. That incorrect decisions are identified and corrected promptly. That is how a company sustains itself and continues to develop. When assessing liability, one must examine the specific circumstances of the case, why the replacement was not secured, whether the failure could reasonably have been foreseen, how procurement was conducted, and under what conditions. Was appropriate equipment purchased from the outset? Were transparent procurement procedures followed? Were purchases made from affiliated parties? Were contracts awarded to newly established companies with minimal charter capital? A company with a very small share capital in a highly competitive market? At the same time, there are situations where the market is monopolized and there is only one supplier. In such cases, there may simply be no alternative but to purchase from that supplier. Natural monopolies are regulated under specific legislation, and that is a different matter altogether. Therefore, in each individual case, liability may arise or it may not, depending on how both management and the board acted. Did they act in compliance with internal policies, applicable law, and established procedures? Did they act in good faith and with due care as a reasonable person would? This brings us to the concept of the reasonable person. In antitrust law, for example, there is the notion of the average consumer. In corporate governance, the question is different. How would a reasonable and prudent person have acted under the same circumstances? A reasonable person, in Ukrainian court practice at least as it has developed so far, may not always be expressly defined, but in essence it refers to an individual who is appropriately qualified for the role. That is, someone who could realistically be appointed to such a position, a professional with 20 to 30 years of experience, relevant education, perhaps from CGPA or UCGA, and a clear specialization, whether in compliance, engineering, finance, or another relevant field. Such a person would typically be selected through a transparent and competitive process. We therefore proceed from the assumption that this is already a reasonable person. It is not someone without relevant background, just with all due respect to any profession. Membership on the board of a serious company is not an entry-level role. A person without appropriate experience, reputation, and expertise would simply have no realistic chance of being appointed.
The question then becomes, to what extent can owners, whether the state or a private individual, accuse top management and board members of failing to foresee certain risks and demand compensation? Take the earlier example, an underfunded modernization program, equipment failure, and long delivery times for replacement parts. A similar situation may arise with personnel. For instance, modernization is funded at 100%, but employee retention is underfunded. As a result, a significant portion of the workforce leaves the company. Given current labor market challenges, it may be extremely difficult to recruit replacements, and the company may again be forced to suspend operations. Not because of equipment failure, but because there are no employees to operate it. Such decisions are inherently based on compromise, and the associated risks may materialize. Can an owner rely on those risks and their consequences to accuse management and the board of wrongful decisions and seek compensation?
Again, each case must be assessed individually. If I were an owner and believed that losses had been caused by negligence, recklessness, or bad faith, I would first consult legal counsel. Lawyers would assess whether there are grounds for a claim and whether the facts support it. They would also evaluate the likelihood of success in court. especially if the actions of supervisory board members or other officers are covered by insurance. Because the first thing insurance provides, when such coverage exists, as it is not always in place, is financial protection against potential claims. An insurance company will first conduct its own assessment. Did the supervisory board member act with due care, in good faith, and in the proper manner in the interest of the company? If the insurer concludes that these standards were not met, then the insured event will not be recognized and the claim will not be covered. After that assessment, would I, as an owner, decide how to proceed? I would also take into account the fact that if I built the business myself, rather than inheriting it, I understand its context and risks. We assume that I too am a reasonable person and capable of distinguishing where the supervisory board or management acted properly and in good faith and where they may have fallen short. My decision would depend on that analysis. The situation in state-owned enterprises is often different. I have not personally served on such boards, but in companies where corruption schemes have historically existed, criminal proceedings are frequently initiated. New management teams or supervisory boards, upon taking office, often file claims or reports of alleged offenses. Sometimes this is not even primarily about recovering damages or securing convictions, but about protecting themselves, creating a clear record that any questionable actions occurred before their tenure, so that later, if asked, "What did you do?" whether by prosecutors, NABU, or other authorities, they can respond, "We filed a report with you, we initiated legal proceedings."
We have mentioned risk insurance for top management and board members several times. Does such practice exist in Ukraine? I know that internationally it is widespread. When I served as CEO of a public company listed on Euronext, my liability as CEO was insured together with the liability of the board of directors under a D&O policy. How does this function in Ukraine?
It does exist, although I would not say it is yet a common or widespread practice. As far as I understand, D&O insurance is mandatory in state-owned companies and in banks or other financial institutions. In private companies, it is not mandatory, and the same applies to municipal enterprises. It is typically subject to agreement with the owner. For example, at Mykolaiv Vodokanal, we are not currently insured, although we are considering it and plan to raise the issue when the time is right. At the moment, however, there are more urgent priorities. An interesting case was reported regarding the supervisory board members of Energoatom. They were insured for 1 year in the amount of UAH 19 million, if I recall correctly. There was also a notable exclusion in their policy. According to media reports, the coverage allegedly applied worldwide except for the United States and Canada. I can speculate as to why the US might be excluded, but I am less certain about Canada. In the US, litigation risks are extremely high and legal costs can be substantial, a slogan that illustrates this reality. Millions spent on lawyers' fees, then not a single cent paid out to those who were meant to be compensated under the policy. So, according to what was written, the coverage was global, except for the US and Canada.
Are there insurance companies in Ukraine that offer such liability coverage?
First, there are not many of them. I will not name specific companies, that would amount to advertising. But such providers do exist. One needs to explore the market. For now, this is not a mass market product, and that is understandable. Professional liability insurance in Ukraine has developed slowly. Even lawyers' liability insurance took a long time to become available. Our firm holds a professional liability policy covering our advisory services, but it took considerable time before we were able to obtain it because insurers did not offer this type of coverage. There is mandatory insurance for certain types of enterprises and specific forms of ownership, but for the rest, it is not compulsory. Logically, especially when foreign professionals join Ukrainian boards, they often expect such coverage as a standard safeguard. In practice, if there is no D&O insurance in place, they may simply decline the appointment.
That is understandable, as this is a well-established international practice. State-owned companies, by their nature, are frequently exposed not only to commercial risks, but also to political factors. Given that political considerations may influence certain decisions, ensuring liability is highly advisable. Are there known serious cases in Ukraine where insurers have actually paid out under such policies?
I am not aware of specific examples, although that does not mean they do not exist. When a potential insured event arises, the insurance company initiates its own review. First, coverage is typically suspended or not triggered if a criminal case has been initiated. Second, the insurer conducts due diligence to assess how the board member acted, particularly if the claim concerns an individual director. Only after that assessment does the question of payout arise, and even then, it depends on the scope of coverage. Coverage may be limited to legal defense costs, or it may extend to compensation for damages. damages, including in some cases non-pecuniary losses. The exact scope varies from policy to policy. I do not have detailed statistics, as we have not personally handled such claims. I suspect that first, relatively few companies in Ukraine are insured, and second, the number of insured events has so far been limited. However, I am certain that some colleagues in the legal field have encountered such cases. I have not previously researched this practice in depth, but the question is genuinely interesting. I will look into it and perhaps share insights next time.
As corporate governance continues to develop in Ukraine and as the insurance market in this area matures, such cases will inevitably arise. And that is entirely normal. Otherwise, the mechanism itself would serve little practical purpose. Sergii, we always emphasize how important it is for the minutes to clearly record who voted in favor, who voted against, and who abstained. This is because when questions of responsibility arise in connection with a decision, such minutes, where individual votes are documented, can be very useful for determining accountability. How does the board's collective responsibility as a governing body work when reviewing such minutes, especially in situations where some members abstained, some voted in favor, and others voted against?
First of all, it is necessary to verify each time whether a quorum was present. There was an interesting case, without referring to the exact case number, as I don't recall it now, where a supervisory board had 5 members with a quorum of 3. 3 members voted in favor, so the decision was considered adopted. Afterwards, one of the members reconsidered and said, "I withdraw my signature." The court ultimately concluded that a signature cannot simply be withdrawn after the fact, and so on. The quorum must always be verified because it is fundamental. If there is no quorum, there is no valid decision. Next, how each member voted is of course important. If the adopted decision later leads to negative consequences for the company or for those who made the decision, there may be derivative lawsuits, bankruptcy proceedings, or even criminal cases depending on the circumstances. If a person voted against the decision, especially if they recorded a written dissenting opinion, while such a concept is not formally defined in corporate law, it is recognized by analogy in court practice. Then claims are unlikely to be brought against them, and investigators will probably have fewer questions for that person. In that sense, how one voted is indeed important. Yes, absolutely.
What other additional methods could be used to reduce one's risks as a member of the board when making decisions?
First of all, I would say awareness and proper understanding. In other words, if you are not certain about something, especially if it is outside your area of expertise, I would, for example, ask the board not to adopt the decision immediately, but to review the matter further, possibly engage external consultants, or conduct a new valuation if one is required. In other words, approach the matter carefully. Review the market independently if it concerns a sale. If these are significant transactions, particularly related party transactions, there are usually comparable market benchmarks. It is very rare that no comparables exist for a sale except in cases involving a truly unique asset for which no substitute exists. Yes, in principle, you can always look into it, but a great deal also depends on how well the board functions as a team. If the board operates cohesively, these issues are usually resolved effectively. If someone identifies a potential risk, even if it later turns out not to be a real risk, they can raise it and say, "Colleagues, let's examine this point more closely." Then, if the board truly works as a team, the response is straightforward. Tasks are assigned. The corporate secretary receives certain instructions, the CEO others, specific documents are requested, the CFO is asked to provide financial information, and the legal team is tasked with reviewing the relevant aspects. The matter is reconsidered, and the board arrives at a well-thought-out decision.
In other words, every decision must be balanced and carefully weighed, and a board member should feel confident that when they vote, they are making the right decision. This is not a casino. Decisions must be based on analysis and calculation.
Exactly.
A board member should fully understand the issues they are voting on. From time to time, when new boards are formed, or when board membership is refreshed, new members are invited to join. Naturally, they often conduct their own review of the company's situation in order to confirm whether they are comfortable joining the board and supporting its decisions. Are there any criteria or factors that one should examine beforehand to be confident that joining a board will not expose them to liability for actions they were not involved in? Are there any red flags that should guide such a decision? In other words, how does one decide whether to join a board or not, specifically from the perspective of potential liability?
Strictly speaking, there may not be universal red flags. However, in large state-owned enterprises that periodically appear in corruption scandals or where public registries show criminal cases, numerous lawsuits or similar issues, reviewing that information can certainly influence whether a person is willing to assume that level of risk. Today, much of this information is public. There are registries, reports, and many sources from which relevant data can be obtained. It is also useful where possible to speak with former board members or members of management management, especially if there has been a change in management or the board. If previous members left amid scandals or resigned because they refused to sign certain decisions or documents, that would certainly be a red flag for me. I would definitely try to understand why that happened. For example, there was the situation at Ukrenergo where a CEO was appointed, removed 3 months later, and then reinstated just 2 days afterward. Situations like that clearly indicate that something unusual may be going on. In such cases, one needs to think carefully about whether to join the board or not and make an informed decision. Ultimately, it comes down to information. Those who have information hold power, and if they can not only obtain that information but also properly analyze it, the risks can indeed be reduced.
Exactly. Even if formal legal liability does not arise, reputational damage may still occur. If a board member joins a company's board and legal issues arise later, issues that may also involve the board itself, this raises an important concern. Sergii, many business owners are actually quite skeptical about boards. They often operate with two conflicting considerations. On the one hand, when they first establish a board, they are reluctant to immediately transfer real authority to the supervisory board. Instead, they prefer to go through a transitional stage with an advisory board. On the other hand, they frequently argue that members of an advisory board bear no responsibility for the recommendations they provide to top management. How can this argument be addressed?
One possible response is that if such responsibilities are stipulated in the contract, then contractual liability can arise, for example, for disclosure of confidential information covered by an NDA or for violations of non-compete clauses. Tort liability could also potentially arise if a board member provided consulting advice and that advice was clearly flawed, leading the company to suffer damages. In those two situations, liability may indeed exist. In other cases, however, legislation typically does not provide for such responsibility because advisory bodies are not formally regulated in the same way as governing bodies. At the same time, certain responsibilities can be included in the company's charter documents when establishing a consultative body. However, anyone joining the advisory board would need to agree to those conditions. As for the transitional period, I have different views depending on the particular company. Some owners simply want to observe and assess how the system works. Others, frankly speaking, are mainly trying to save money. I recall an interesting story from when I was finishing the INSEAD program around 2018 in one of the early cohorts. At those sessions, there was always a guest speaker whose name and company were not publicly disclosed. One time, a shareholder of a very successful Ukrainian company, built from scratch and operating according to European standards, came to give us a lecture. They had already established a supervisory board. Someone in the audience asked him, "Can you actually tell supervisory board what to do?" And he answered, "Come on, of course, I'm the one paying their salaries." That was 6 years ago. And these were considered progressive owners and progressive companies because people simply need time to get used to it. If someone has been the sole leader, someone who built the company on their own, they may simply not be used to hearing the word no. Then suddenly the board says, "We disagree," or "This may not be the right approach." In other words, it would be better to do it this way. But imagine a person who spent 30 years building a company from scratch. They selected their team, sometimes without recruiters, simply through personal judgment, and now those same people start telling them how things should be done. There are even cases where the owner returns fully to the business and says, "We don't need a board, you don't know how to do it, I'll handle it myself," especially in difficult times such as during a war or other crises. Sometimes that decision may actually be the right one, at least in certain situations.
In general, however, it is often assumed that every owner should eventually plan to step away from day-to-day operational management. In reality, though, many owners, although they are entrepreneurs, are also quite strong. Managers who build effective systems and understand those systems down to the smallest operational details. Therefore, it is not necessarily true that every owner must eventually step away from managing the company, just as it is not necessarily true that every owner needs to establish a board. Some will be ready for it, others will not. However, a board can unquestionably provide competitive advantages to a company, at the very least by offering an independent perspective.
That independent perspective can help attract investors, secure financing, and access foreign stock exchanges, where strong corporate governance is often a prerequisite. There is also an interesting example related to this. We have an association of family-owned businesses, where all shareholders are members of the same family. In many of these families, it is already understood that the business will eventually be passed on to the next generation. Or alternatively, they may realize that their children are simply not interested in running the business. They may want to paint, sing, or pursue something entirely different. Or they may not have the necessary capabilities. In such cases, external professional management and an independent board may become necessary. But if it is a family company and there is someone willing and capable to inherit and run the business, then why not continue in that way? There are both advantages and disadvantages in such companies.
Both strengths and weaknesses. Many companies that are family businesses by nature, where the owners are members of the same family, eventually develop the intention to transform into a fully corporate business. In other words, they aim to remove the family-specific elements and operate strictly as a corporate structure. On the other hand, many companies are genuinely family businesses and intentionally want to remain that way. In such cases, maintaining family unity and planning the careers of family members within the company becomes a real art. For example, consider a situation where a company experiences a cash gap, that is, a temporary shortage of funds. As a result, the company may have to delay or default on the timely fulfillment of its obligations. Naturally, other parties, including even the state, for example, if taxes cannot be paid, may accuse the company of failing to meet its obligations. How should the board of such a company behave in order not to appear complicit in this situation?
Personally, I believe this falls primarily within operational management, and the board should generally not interfere in day-to-day operations. At the same time, if the cash gap or the amount of unmet obligations becomes significant, so large that it could potentially lead to bankruptcy proceedings or, for example, a tax lien if the tax authorities go to court, then the situation could escalate further. Creditors might sell the debt, for example, to raiders who could attempt to take over the company through bankruptcy procedures. In such circumstances, if I were the director, I would inform the board and report that there is a problematic situation. Although this still concerns operational matters, boards often include members not only for their expertise, but also for their professional networks. In that case, the board might help facilitate a short-term solution, perhaps arranging temporary financing, an overdraft, or another financial instrument. At the very least, the board could help assess the risks, whether the cash gap is temporary and likely to be resolved soon, or whether there is a risk that long-term suppliers might sell their claims and initiate bankruptcy proceedings. Nevertheless, in principle, I still consider this primarily an operational matter. That said, the company's charter documents may provide otherwise. Moreover, legislation often contains provisions stating that if management sees that the company is approaching insolvency, they are obligated to file for bankruptcy themselves by applying to the court.
Well, that's normal, right? A properly functioning supervisory board should ideally anticipate such financial deficits or cash gaps in advance.
Well, of course.
It is difficult to imagine such a situation occurring if the supervisory board is operating effectively and all proper control mechanisms are in place. Although theoretically, in cases of force majeure, any situation can still arise. Sergii, for example, what happens if top management actually concealed part of the information and because of that, the board made an incorrect decision? Whose responsibility is it, and how can board members prove that they are legally clean before both the law and the shareholders?
In such a situation, the first thing I would consider is how to reverse the decision if it is indeed incorrect, either by reconsidering and re-voting on the matter or by going to court if the process has already gone further and the relevant transactions must be challenged. If I understood as a board member or chair of the board that management had done this deliberately in order to obtain some form of personal benefit, then I would certainly consider suspending them. If the law and the company's governing documents allow it, I would suspend them from their duties and potentially report the matter to law enforcement authorities. That would clearly document the situation, that the board was provided with incorrect information and therefore made an erroneous decision, and that we responded appropriately once this became clear.
Another question, how should board members act if they have signed very strict NDAs with serious financial penalties, but are approached by a market regulator or law enforcement authorities requesting information about the company's activities?
First of all, this again relates largely to operational matters. Such information should normally be provided by the company's management, primarily the CEO and the legal department. There are mandatory legal provisions that override confidentiality, even if the information is confidential or constitutes a commercial secret, or even something like banking secrecy. If there is a criminal case and a court order requiring disclosure, then there is no question. The information must be provided. Otherwise, you may face legal consequences yourself. If there is no such legal basis, you can politely decline. But in principle, this remains a matter for the CEO and the chief legal officer.
From time to time, conflicts of interest may arise for board members. How should a board member act when such a conflict occurs in order to avoid liability for improper decision-making?
First of all, it depends on when the conflict arose. If the conflict existed before you joined the board, then, in principle, you should not join that board. If you are acting in good faith, you should disclose it and refrain from accepting the position. If the conflict arises later due to circumstances, then you need to assess the situation. For example, imagine you are a board member and you marry a supplier of the company, someone who has been supplying the company for many years. Clearly, divorce is not the solution. In such a case, you must disclose the conflict. Depending on the circumstances, you may need either to resign from the board or at least abstain from voting on related matters, although in some situations resignation may indeed be the safest option. The most important principle is that a conscientious board member must promptly disclose any conflict of interest. After that, the resolution will depend on the applicable legislation, the board's decision, the company's charter, or its internal governance policies. You simply have to disclose it. If you fail to do so, you must understand that you will bear responsibility and that you have also put your colleagues at risk.
How common is the practice for board members to have a contract with a law firm or legal advisors who specifically support them in their role as board members?
As far as I know, in state-owned banks, such arrangements exist across the board. In other state-owned enterprises, I am not entirely certain, but I believe this is also the case. In fact, it is almost a necessity. What is interesting is that this law firm is usually not the same one that provides legal services to the company itself. Instead, it specifically advises the supervisory board on matters related to its duties. In other words, the company may, and very often does, retain a different law firm for its own needs, or it may rely on its internal legal department. But in practice, especially in large state-owned companies, tenders are often held, for example at Energoatom, specifically for legal services supporting the supervisory board and its activities. This is quite a common practice. In private companies, however, I would not say this is standard. Ultimately, it depends on the shareholders or the owner. If they want such legal support, they arrange it. If not, it remains their choice.
Sergey, thank you very much for sharing your thoughts, examples, and advice. Thank you very much.
Thank you for the invitation. It is an interesting topic. I believe corporate governance will continue to develop. Inevitably, disputes will arise. The key point is that once such disputes occur, judicial practice must develop so that there is clarity on how these issues should be resolved. As Americans often say, the law is not what is written in the statute, but what the court ultimately says about it. That is how it works. Of course, it would still be preferable for conflicts to arise as rarely as possible. Overall, our legislation in this area is fairly solid. The main task now is simply to continue developing it.
Thank you very much.
Thank you.
Ladies and gentlemen, thank you for being with us. See you in future episodes.